Liverpool, please. We have a slight difficulty.
Meester Liverpool, meester Kracht. We hebben
that,
een kleine verhindering.
Yes,
Oh,
sorry.
amen.
Do we need the interpretation now, Madam Registrar? The volume down. Yeah. I think due largely to our own deficiencies, we perhaps did not get the clarity on two issues yesterday that we wanted. And you may be able to help us by agreeing what the answer is to those two issues. First is the question of whether someone can be detained lawfully in Suriname without a detention order. And the second is, what is the effect of a Beperkin order being found to be unlawfully issued? And in particular, what is the effect of the underlying criminal proceedings? Are you able to agree and answer to each of those questions for us? Because if you're not, we happen to notice that your expert witnesses are here. And we would have no difficulty in having them help us on those 2 points.
Your Honor, on the part of the claimant, can I suggest I be permitted to speak to my learned friend and to my expert witness in connection with those two questions? It may or may not be that we can agree. I am not certain that it was unequivocal in the evidence, and therefore the Honours are quite correct that perhaps requires clarification.
Okay, Mr. Liverpool, would you agree to that course of action?
Yes, Your Honor. I think it's best if we ask the experts.
Yes, okay.
Why they are the experts.
And of course, if the experts don't agree, then we'll have to hear them from the box. Okay, so shall we then rise for, how long would you need, 10 minutes or so?
Or could we have 15 so that we do not inconvenience you?
Chair, can I maybe invite you to just repeat the questions? I don't know if they made a note, so at least they would be asking what you want.
Okay, so the first question is whether it is lawful under the laws of Suriname for someone to be detained by the public authorities without a detention order. And the second question is, what is the effect on the underlying criminal proceedings if a Beperkin order has been issued and the suspect makes incriminating statements during interrogation whilst under the Beperkin order?
Sorry to disturb you with this, Your Honor. Can I ask that the second question be repeated? There was a word that you used that I'm not sure I got. Unaligned criminal proceedings.
Yes, because I understand that the whole point of the Beperkin order is to prevent the accused from communicating with his or her attorney for fear that that communication might undermine the underlying criminal proceedings contemplated against the suspect. So what I want to find out is, in the event that the Beperkin order is found to have been unlawfully issued, what effect does that have on the underlying criminal proceedings?
Thank you. Thank you very much.
Is that clear?
Thank you.
So we'll rise for 15 minutes.
I'm very grateful.
Thank you.
All rise.
I want the two of you.
Thank you. Counsel?
Your Honors, thank you, and we're very grateful for the opportunity to speak. The answer to the first question is the same on both sides. That is, that there must be a detention order in order for a suspect to be detained. The
There
second,
must be a detention order, and that order necessarily must be in writing or
yes,
not?
a
In writing.
written
Written
detention
detention
order.
order. Okay, we're clear on that. Thanks.
I beg your pardon, sir. Mr. President, the second question, there are areas of agreement and an area of disagreement. It is agreed that if a beperking is lifted, there are certain consequences that can potentially run from it. My learned friend for Suriname, his position is that any interrogation that has been derived from the period over which the beperking is operative can still be used. On our side, our instructions from the expert are that that is correct, but there is a theoretical possibility of it not being used. I am not sure whether that does not create more confusion than clarity, but perhaps my learned friend.
Yes, before you say it, you use the word lifted, the beperking order being lifted. Are you saying that the beperking order was declared unlawful?
Yes.
That
I beg your
Oh, I
pardon.
see,
In
right.
circumstances where the beperking order is declared unlawful,
Yes.
the State of Suriname says that notwithstanding that, the material derived during the course of interrogations, whilst it was in effect,
Yes.
can still be used.
Yes.
The claimant's instructions are that that is correct, but there are certain applications that can be made theoretically that could see the invalidity of any confession being declared, but my instructions are that that is not in practice. It does not happen in practice.
Right. So the exceptions to which you refer would be analogous to the notion of not using the fruit from the poison tree. Am I?
Yes, and that is where I think perhaps it might be useful to hear from Mr. Limapo, because his position is that the fruit of the poison tree can be used.
Can be used.
Our position is that it is in practice used, but that there is an application provided for under the laws of Suriname, which could lead to the confession being declared invalid, but it is not used in practice.
Understood. Thank you, Counsel. Sir.
Your Honor, the first question, that's correct. Yes, the answer to the first question is correct, as just provided by my learned friend. We share that answer. The second question, we're not far away from each other. It sounds further when you, depending on how you phrase it, but actually I think we are both almost in agreement on that. In that sense that if the beperking order is declared unlawful
Yes.
by the Court of Justice, then the evidence that was given in the time in between is not unlawful by operation of law, so it can still be used, but there is a possibility of addressing the court with regard to that and trying to get such evidence dismissed.
Yes. Discretion. It sounds to me that you are both saying the same thing in different words. I'm not, my sister, I don't know if you have another view, members of the bench, but it seems to me that you are very much agreed that the evidence obtained during the period of the beperking that was subsequently found to be unlawful, that evidence can be used in the underlying criminal proceedings. However, there is the possibility of making applications to the court to strike out the use of that evidence. Is that a fair summary of what you? Okay. Yes. In practice, it is used. Okay. Good. Thank you very much.
Mr. Phelps, one matter of clarification. The declaration of unlawfulness that you speak about with respect to the Perkin order, just to get it right, that would mean that there was an application within the first 3 days. That's what I want to find out. No other application taken at a later time as to the lawfulness of the Perkin order.
Your Honor is quite correct. I understood the question from the court to assume such an application and such a declaration.
And that is so, Mr. Limpo.
Yes, Your Honor.
Thank you. Thank you very much.
Well, thank you both. I think you have assisted us tremendously well. We do not think we need the services of the experts on this occasion, but stand by. Who knows? The day is early yet. Please.
Your
would
Honor,
you- yes.
I just one more remark. It doesn't have to mean that the application for, let's say, dismissal of the evidence is done within the 3 days. That's not necessary. You could do it at a later stage when the underlying procedure moves on.
Yes.
Thank you, counsel. Could you just clarify for us the relevant provision under which this application you're referring to would be made? So you're making reference to the possibility of an application for having the evidence struck out. If not now, at some point, could you direct us to the relevant provision of the Code of Criminal Procedure otherwise that governs this? Thanks.
Your Honor, that's not a specific provision. It's actually when the underlying procedure goes for trial, you raise an objection as to the evidence that has been raised, and then it can be dismissed.
Okay. Thank you again very much. So I think we resume day 2 with counsel for the claimant making submissions on behalf of the claimant.
Thank you, Your Honors. I propose to deal with the closing submissions for the claimant by giving a summary of what we say our case is, taking you to the facts which we say have been proved, and then to our submissions on 3 legal questions which arise, which are the interpretation of the RTC, the question of the applicability of the Charter of Civil Society, and the question of the status of the Perking as it relates to RTC rights. The case for the claimant is that the right to freedom of movement enshrined in the RTC is not effective unless it is exercisable in an environment that protects basic human rights. Those minimum conditions, we say, are necessary for the effective exercise of a right to freedom of movement enshrined under the RTC. And we say that they include matters such as access to legal counsel, protection from arbitrary detention, and cruel and inhumane punishment. We submit that that is the result of a legally correct interpretation of the RTC under the provisions of Article 31 of the Vienna Convention on the Law of Treaties. In connection with the specific facts of the claimant's case, we say that in point of fact, he has been prejudiced in the exercise of such a right to freedom of movement in the events which have happened and which I would develop with reference to the documentary evidence in a moment. The claimant for this case relies on the judgment of this court in Shanique Myrie against the state of Barbados. And it is helpful as a jurisprudential marker to point out that in the case of Myrie, what the court did was assess the conduct of the member state and conclude that the conduct of the member state in subjecting the claimant to an outrageous body cavity search was a violation of her right to free entry into the state of Barbados, as elaborated upon in the 2007 conference decision. That is important because it is an evaluation by this court of the conduct of a member state touching and concerning enshrined rights, yet involving the acts of a member state acting within, as it claimed, its immigration and criminal sanction laws. As this court said in Myrie, the full extent of the right to free movement is that a community national can stay in a member state hassle-free and without harassment or imposition or the imposition of impediments. Denial of basic human rights is an impediment to free movement. Denial of access to legal advice is an impediment to the right to free movement. And both experts who have given evidence before you have invoked the European Union Directive 213/48 EU, dealing with specifically the access to counsel. And Note 8 of that directive makes a clear connection between removing impediments, the language it uses is obstacles, removing impediments to the right to free movement or obstacles to the right to free movement by developing a preservation of the right to access to counsel. In due course, when I address you on the facts of this case, I will show you that moving from theory to practice, in practical terms, the Be-Perking measure in the state of Suriname not only infringes the right to free movement, but has far-reaching implications throughout every stage of the criminal justice process in Suriname, which I submit is supported by the report, expert report of Ms. Bruining. Such a denial of basic human rights conditions renders any exercise of the right to freedom of movement ineffective, and their honors can arrive at that conclusion without reference to the Charter and without reference to the Be-Perking in this case, through the application of Article 31 of the Vienna Convention on the Law of Treaties. there is a logical, obvious, and self-evident connection between the right to freedom of movement and a preservation or protection of basic human rights. If I might turn briefly to the question of the Charter. If the court does hold that the right to freedom of movement involves the protection of some degree of basic human rights, then the question arises as to what those basic human rights ought to be. And in the interest of certainty, which this court has upheld as one of the features of the new regional rule of law which it is developing, that question must be answered by identifying what basic human rights are the conditions in which a community citizen ought to be permitted to exercise an effective right to freedom of movement. We will submit, and I will develop the point when I come to give you my full submissions on it, that there is a bespoke code made by Caribbean people for Caribbean people contained in the Charter. And therefore, rather than looking to create a code or looking to decipher what might be contained in the customary international law, this court ought to identify and recognize the Charter as such a code, not only because of its provenance as a document of the conference, but because within Article 31 of the Vienna Convention, it has a preambular status. And that itself, contrary to some of the statements to be found in the text, gives the Charter of Civil Society a legal effect, as we respectfully submit. And we will draw the distinction between statements that say that the Charter is non-binding and unenforceable, and statements that point out that being in the preamble of the ROTC itself gives it a legal effect. The question becomes what the legal effect is. And that is how we propose to address you on the question of the legal status of the Charter of Civil Society. I turn now to the Be-Perking by way of introduction. The only effect of using Article 40, Subarticle 2 of the Code of Criminal Procedure in Suriname is an absolute denial of access to counsel. And that has, within the criminal code, certain implications. It means that you will be interrogated without counsel. It means that you will have to challenge the imposition of the order restricting counsel without counsel. It means that you have to challenge the order that you be detained without counsel. And therefore, it is a complete neutering of the position of a criminal suspect. And there is no alternative to, I beg your pardon.
Let me just ask you something because of the absolute nature of how you put in this proposition. My sort of takeaway from the evidence of the experts is that the Be-Perkin order, the mischief that it seeks to address is where an identified or identifiable counsel lawyer, if allowed contact, communication with a suspect, because the person is now a suspect, can undermine the investigative process. So if that is a correct model, then it can be exercised as a scalpel and not as a machete. Meaning, it can say that counsel A or counsel B are counsel who we will apply a Be-Perkin order in relation to. So party Z has counsel A, but counsel A is also acting for parties C, D, and E in the same factual matrix which we are investigating. And so we impose a Be-Perkin order to say, counsel A, no communication. That is a use of the order as a scalpel
Yes.
to protect the integrity
Yes,
of
Your
the
Honor.
investigative process.
Yes, Your Honor.
But it's not, therefore, necessarily, and your language is, the absolute. Because if that is a correct interpretation, and I'll ask the state the same question, it therefore allows for other counsel under your right to access to counsel to act on your behalf.
Not in Suriname. So,
Not in Suriname in theory or not in Suriname in practice?
Not in Suriname in theory or in practice.
Okay.
And this is one of the points. Can I answer you fully in this way? One of the points that arose out of the expert evidence is that the Netherlands has amended the equivalent provision to ensure that when there is a problem with access to counsel Jones, a substitute counsel is appointed so that all of the several things that happen during the course of criminal process do not occur without a lawyer. In Suriname, the position is completely different. You are denied counsel. So can I ask, Your Honor, with your permission, could we use an example of a Be-Perkin that is completely justified? We have a suspicious lawyer who is engaging with a suspicious client, and he is in the custody of the state, and the Be-Perkin is unquestionable. That criminal suspect in Suriname has to face the following three things without any legal counsel at all: interrogation, exercise his right to challenge the Be-Perkin, and defend his position with regard to detention. In the Netherlands, that same person with a justified Be-Perkin made against him does those three things with the benefit of legal advice. And that is why I put it in such absolute terms, because it is on the letter and the practice of the Be-Perkin exactly what happens. It is what happens in practice, and you will find that in the witness statement of Mr. Dubois, and it is what happened in the case of this client.
Counsel, help me here. Without forming any view as to the absolute nature of the Be-Perkin order or otherwise, I am looking at the fact that a lawyer on the 8th of October wrote to the authorities to say, I represent this person and I want to know where this person is. How should the court look at the fact that a lawyer purported represented herself to be acting for Mr. Ramsamooj? Thank you.
Your Honor, can I start by referring you to the questions that His Honor, Mr. Justice Jamida, asked of the Surinamese expert, trying to get clarity as to what happens, because it is exactly what happened in this case. It may be that His Honor, Justice Jamida, had in mind the document at 195 of the record, which shows that when he went in on the 7th of October, he was not a suspect. He became a suspect during the course of the questioning on the 7th. In the exchange between His Honor, Mr. Justice Jamida, and Ms. Bruning, it became clear that it really was up to the family to try and find their person and to try and find assistance. Now, can I underscore that by referring you to the facts in this case The facts in this case bear exactly that out. When you look at the witness statement of Ms. Paji, contrary to what Mr. Rampersad may have wanted you to believe, what happened in this case is Ramsamooj, and I will be making this submission in a moment if you would permit me, whilst in the custody of a member state, disappeared. He went in on the 7th. A lawyer contacted via a third party by the wife wrote, apparently she went, a proper understanding of the letter is that she went to the police station at Kaiserstraat, made inquiries, and was told, he is not here, and we can't tell you where he is. And that was the end of Lalji as far as the record in this case is concerned. I asked Mr. Rampersad in his cross-examination whether there was any written response to this letter produced. His answer was no. He gave evidence as a man who is a member of the repository of the file, and he did not depose in his witness statement to say that letter was responded to by a telephone call from Mr. Pierkan to the family. So all of the documentary evidence in this case, Your Honor, Mr. Justice Barrow, supports the questioning and answers that took place between His Honor, Mr. Justice Jamada, and the witness Bruining. The family must find their person. I don't want to be rhetorical as some counselor. I am cautious. But you check the prisons, you check the hospitals, you stumble upon something, and you do your best. That is how it works. And therefore, we feel that we are right to submit to this court that the effect of the be-perking is always to deny your access to counsel at a time when prosecution and police are aware that you're going to have, under the rules of Suriname, to deal with your objection to the be-perking, to deal with your interrogation, and to account to the court for whether you ought to be detained or not. If that, or if those are the facts found by this honorable court, then the question becomes whether that is in order in the Caribbean community.
And what you are saying is that Ms. Lalji, having written that letter, was thereafter, on the facts of this case, simply excluded, played no role.
She was. There is a letter. I have a duty of candor to the court, and I want to answer you therefore fully. There is a letter dated the 16th of October. It was not translated. We have undertaken, at the request of the President, to prepare a translation of it. The evidence at this stage is that Mr. Rampersad was able to tell me that what it records is the withdrawal by Ms. Lalji of an objection she intended to take to the be-perking, but the grounds of the withdrawal are important. She withdrew it because the prosecution said in a courtroom, this particular man doesn't want you to act for him. And that is the extent of the evidence of the involvement of Ms. Lalji. She is at one moment looking for a disappeared criminal suspect, and at the next moment confronted in a courtroom with having to withdraw an application because the prosecution is saying the criminal suspect doesn't want anything to do with her.
Just again, Mr. Phelps, not to flog the point, I just want to get the nuances of what took place correct. Because Mr. Ramsamooj's case is that he was in, as it were, almost total isolation. So it is for this reason I'm pushing. It appears, therefore, that on the 16th, when Ms. Lalji said, I am withdrawing, she considered herself to have been, as it were, active or connected or participating in the case, and my participation was such that I had filed or I was proposing to file an objection but no, I have withdrawn or I am withdrawing. So her nexus with the case, it seems to me, must have been extant for her to withdraw. This is what engages me. And I'm indicating to you again, it is not that I have
Yes,
formed
no.
any view.
The claim-
I just want to get
Yes.
the nuances
The
correct.
claimant,
Yeah?
the claimant doesn't run from that. On the 8th, she wrote a letter, that is Ms. Lalji, indicating that I want to act for him, I can't find him. On the 16th, she writes a letter saying I'm withdrawing an application. The claimant is not saying that Ms. Lalji was not trying to represent him. The claimant is saying that he had no access to any lawyer. And in substance, and this is where...
I am very clear he had no access. Trust me.
I beg your pardon.
I think that is one of the clearest
But
things
yes.
in the case.
Yes, but the substance of the thing is very important. The legality of the thing has to be addressed through the substance. And the substance is that because the two of them couldn't speak, there is mass confusion with regard to a legal defense. And His Honor only needs to imagine the scene of being in a court where criminal proceedings are in question and an attorney trying to lodge a defense is being told that you can't speak, you have no locus standi, the suspect doesn't want you. So the claimant's case is not running from the fact that Ms. Lalji was trying through the efforts of the wife. The claimant's case is based on the refusal by law in Suriname to grant him any opportunity to access legal counsel. And we say that that is the effect, Your Honor, of the application of the BPERKing, and we say that its effects in this case are far-reaching and agreed, as His Honor, Mr. Justice Barrow pointed out to me yesterday when I was taking perhaps too long about a particular point. The state of Suriname accepts that the BPERKing was imposed, the period of time over which it was imposed, and therefore the state of Suriname accepts the implications of that. And therefore, the question for the Honorable Court is whether in the Caribbean community, a criminal suspect faced with such conditions has an actionable position on his right to freedom of movement within the community. So those are that is a legal summary of the claimant's case. I beg your pardon, Your
Mr.
Honor.
Phelps, having provided the summary, I just want you to clarify, in your submissions and in the originating application, there is a claim of denial to not only the right to freedom of movement, but also the right to provide services and the right to movement as a skilled national. I'm seeking clarification as to whether that's the scope of the treaty rights that you're saying were denied by virtue of the detention of Mr. Ramsamooj, or whether your focus is on right to freedom of movement, say arising from the 2007 conference decision. I just want clarity on that, please.
Your Honor is quite correct. I apologize. I had intended to seek your permission to use freedom of movement as a shorthand for the body of RTC rights that the claimant wishes to agitate in these proceedings. So that when I say freedom of movement, I really am hoping to agitate the freedom to provide services and all of the rest of the rights. The same legal submissions are made by the claimant in connection with each.
And so just as a follow-up, and you probably will elaborate on this because you are providing a summary, I would just request when you do get to that point to please clarify how you see the detention having infringed the right to provide services, and if your focus there is on literally the right to provide services through moving to another territory or otherwise. So if you can just clarify the ways in which, because you're saying movement, so I'm taking that literally to mean you're finding that the denial occurred because of his inability to travel or to move physically. So if you can just clarify that when you get to addressing the denial of the rights. Thank you.
I should do so, Your Honor. The claimant now wishes to address you, Your Honors, Mr. President, on the facts of this case. To a substantial degree, Your Honors would recognize that the state of Suriname has not disputed these proceedings in point of fact. There is no evidence from the prison service. There is no evidence from the police service. What you had is a single witness of fact from the office of the prosecutor. He was asked yesterday by Her Honor, Madam Justice Onowanu, whether he had been himself involved.
I think my sister prefers the pronunciation of Onaniwu. Onaniwu, yeah. Just for the
I
record.
beg your pardon, but
That's
can I, in my defense, can I say that I have practiced it, and the fact that I'm
We're
still,
sure you have.
the fact that I'm still getting it wrong is something
No, it's
that
Onaniwu,
causes
that's
me
all. Yes.
embarrassment.
Thank you.
But the question was asked yesterday in connection with whether the witness of fact was present during the interrogations that had been translated and put before the court. And of course, the witness said no. Mr. Pearcan was conducting the interrogations himself, an officer called Mr. Soko, and another officer called Mr. Ramsamooj. None of them have given evidence to you in connection with the early stages of the claimants being in the criminal process, and no evidence is coming from the state of Suriname in connection with the prisons and the conditions under which the claimant was kept. No evidence is produced contrary to the medical evidence, and the medical expert is not cross-examined as to any of the matters about which he testified. Can I take you briefly then to the agreed facts, which is at page 263. And commend to the court's attention paragraphs 3 in the main through to 11, which we submit an admission or an agreement before this court as to the governing facts upon which the claimant is entitled to relief. The story with regard to the facts begins on the 7th and 8th of October. And it is accepted that on the 6th of October, the day before he went into the police station, Mr. Ramsamooj was visited at the apartment hotel where he was staying, and by police, and had his passport seized. That is an important matter of fact because it explains why Mr. Ramsamooj, as of the 6th of October, was in no position to leave Suriname. He went to the station at Kaiserstraat on the 7th of October 2020, and at 8 a.m., and he was subjected promptly to interrogation, during the course of which he was deemed by Officer Pearcan to be a criminal suspect. A beperking order, or an order under Article 40, sub-article 2, was issued in respect of Mr. Ramsamooj at some point.
Mr. Phelps, I just want to intervene to clarify something on the facts. So he goes in at 8 on the 7th, subject to interrogation and deemed a criminal suspect. Now, the second expert yesterday said that when you shift from a person to suspect, there is one fundamental requirement, in her language, to read or to inform the person of their rights. And at that point, including the right to silence and the right to access to a lawyer. I think she also said to be informed of my poor language, the grounds or the basis for being deemed a suspect.
Yes.
So my question is, that's what the expert says ought to happen at that point. So you are on the 7th in the police station, go in there voluntarily, and during the process of the interrogation, you say Mr. Ramsamooj was deemed a criminal suspect. That's what you've just told us.
Yes, sir.
My question is, on the facts, is there, not the cross-examination for now, on the deposed facts, is there evidence that at that point he was informed of his rights?
Your Honor, the only document that I am aware of that indicates that is a document at page 195 or 199 of your record, which we will pull up, in which the suspect is told that he has the right to counsel.
On the 7th?
On the 8th.
No, all right. So I'm on the 7th.
I beg
Because
your pardon.
your statement is, on the 7th, he was deemed a criminal suspect. The expert evidence is that at that point in time, you were supposed to be informed of your rights. So before we reach the 8th, I'm on the 7th.
I'm sorry, in which case what I should have said is that during the course of the interrogation, he was deemed a suspect. You would excuse me, Your Honor, because these interrogations are going from the 8 a.m. on the 7th
Okay,
continuously into the 8th.
I get it.
In fact, he was arrested at 12:15, that is midnight, on the morning of the 8th. But in answer to your question, if I have it correctly, whether his rights were read to him, there is a document that we will pull up in which he is told in one sentence by Perkan or Ramsamooj that you have the right to counsel, and the next sentence is, but there is a restriction in place against you speaking to counsel. And that is between pages 195 and 202 of the record, and we will pull it up for His Honor in due course.
Thank you.
Yeah, just to make the point, counsel, that about 30 minutes of your 90 have gone,
Yes.
in case that helps you in terms of moving forward. Thanks.
Thank you, Your Honor. So there is one piece of documentary evidence in this case that requires, in our submission, to be read to this court. And that is the letter from Ms. Lalji at page 215. She is writing here to the Procurator General at the High Court of Justice concerning Ramsamooj Derek Anand on the 8th of October 2020. And she says, I hereby call your urgent attention to the following. Mr. Ramsamooj Derek Anand appears to have been summoned to the police station at Kaiserstraat for questioning on October 7th and was subsequently placed under custody there. Since he was supposed to travel to Trinidad today and has not arrived, his wife has approached me to find out where he is staying. However, inquiries at the police station located at Kaiserstraat reveal that my client is no longer there and they cannot tell me where he was taken. At the police station, Kaiserstraat, they inform me that Mr. Perkan of the Fraud Department is in charge of my client's case. I hereby urge you to verify this and obtain the necessary information as soon as possible. And that is where the story of his incarceration, which is not to end until the 21st of December 2020, began. And therefore, what you have in point of fact proven before you in this case is that a community citizen in the custody of a member state has disappeared. And that is not overstating the facts of this case. The evidence is that several opportunities arose during the course of which he was interrogated by the police without access to any legal advice. It is important to note that arising out of one of those interrogations is a document which the authorities in Suriname rely upon formally as a confession. And this court has confirmed this morning through its own inquiries of the experts and counsel appearing on the record that that confession obtained during those interrogations in those circumstances is deployable against my client in Suriname to support a criminal conviction.
Mr. Phelps, just to confirm, you are relying on the documents that are at Annex B to the defense of the State of Suriname when you're speaking to the documents containing the confession?
Yes, Your
Okay,
Honor.
thanks.
Thank you. The restriction on his access to legal counsel mandates that there ought to be written communication between the state or the authority imposing the restriction and the counsel and the suspect. That is part of Article 40, Part 2. And for an English translation, I say this for convenience, Your Honors, there is an English translation of that article at page 217 of the record. No such written communication has been produced, notwithstanding that the claimant in this case had asked for production by Suriname of the entire criminal file concerning the claimant.
Just to elaborate on that point, I believe Mr. Rampersad also said that, but he said that this was done and that Mr. Ramsamooj signed a receipt acknowledging that this had been done, i.e. that he had been given the written Biperkin order. So just for the record, is there any document that has been produced that amounts to what Mr. Rampersad said was the written confirmation of receipt by Mr. Ramsamooj?
I would want to check, Your Honor, but I can't give you a partial answer. I hope it goes some way to dealing with your question. There are three documents at 195, 199, and 202 of the record. Yesterday, Mr. Rampersad suggested that 195, may I have a moment, Your Honor? 195, 199, and 200 or 202, and those are annexures to the defense. Two of them are reports that are prepared by police officers to the Office of the Attorney General. The third is a document which appears to be signed by Mr. Ramsamooj, and that is the document in which he is told that he has the right to counsel, but that a restriction had been imposed. So if Mr. Rampersad was speaking about a signed recognition by the claimant that a Biperkin order had been imposed, then potentially that document is the document. But we will check it and confirm that. What I can confirm is that Mr. Rampersad's suggestion to the court yesterday that the documents at 195 and 199 had been signed by Mr. Ramsamooj is inaccurate. I have made the point already, Your Honours, I think, that of the 3 hearings at which Mr. Ramsamooj was called upon to contest his continued detention, no lawyer is recorded as ever having appeared on his behalf. There is in the record evidence that the state of Suriname, during the first month of Mr. Ramsamooj's incarceration there, had been engaged in diplomatic interaction with the state of Trinidad and Tobago. The first such piece of documentary evidence appears at 4113 of the record, in which a diplomatic note sent from Port of Spain, Trinidad, to Suriname appears. And in it, Your Honours will see recorded the fact that the Ministry of Foreign and CARICOM Affairs, in thanking the government of the Republic of Suriname for granting approval for the consular visit, notes, however, that Mr. Ramsamooj has not yet had the benefit of access to his attorney. The ministry therefore seeks the approval of the government of Suriname for Mr. Ramsamooj's attorney to visit him without further delay.
Mr. Phelps, what is the date of that note?
I beg your pardon, the 26th of October 2020. So this note is dated the same day that the B. Perking was being released. And it is important that the B. Perking was being released on the 20th, by an order of the 26th, but curiously effective on the 24th, 2 days earlier. And that diplomatic note continues. The Ministry of Foreign and CARICOM Affairs notes further that Mr. Ramsamooj has not had access to much-needed diabetes medication and seeks the kind and immediate attention of the Ministry of Foreign Affairs, International Business and International Cooperation to ensuring that a medical assessment of Mr. Ramsamooj's health is conducted and that he is provided immediate access to the required medication. 26th of October, at this stage, my client is in prison without a lawyer for 2 weeks, that is since the 8th of October. He has been interrogated constantly. He has missed the deadline to challenge the B. Perking, and he has had 1 hearing to challenge his detention without a lawyer. The second diplomatic note appears at page 4109 of the record. It is dated the 12th of November 2020. And it says, the ministry has the further honor to request clarification with respect to the following. Has Mr. Ramsamooj been arrested or charged? And if so, what is the nature of the charge? There is no English translation response to this, but had there been a response, the documentary evidence before you would demonstrate that the response had to have been, no, he has not been charged, because it is an agreed fact in this case that he was never charged during the period of incarceration. He was charged on the 26th of March, 2021. And it continues, on the basis of legal advice received, the ministry is of the view that Mr. Ramsamooj's continuing detention in an environment of legal ambiguity is improper and takes the opportunity to formally register its concerns in this regard. The ministry would be grateful for a full and urgent response to the matter raised for clarification. Your Honours, as it is not in dispute when my client was eventually released from detention, and as the governing facts in this case center around the period of detention without access to a court and without access to counsel, I am happy to conclude my submissions on the facts by making these points, may it please you. The effects of an imposition of a B. Perking order are well made out in this case, and the effects of that order on my client are established as a matter of evidence before you. What it comes down to, if I were to break it down, is that between the 7th and the 24th of October 2020, my client was without a lawyer, and that period resulted in a signed confession, so the State of Suriname says, which is going to support his criminal conviction in Suriname. Between the 7th to the 13th of October 2020, without any court hearing, a result remained, the result is that he continued in detention. On the 13th of October, the 13th of November, and the 9th of December, the question of his detention arose 3 times before court. At none of those was he with the assistance of a lawyer.
Can you give us those dates again? Thank you.
I beg your pardon. The first, Your Honor, is the 13th of October 2020. The second is the 13th of November 2020. And the third is the 9th of December 2020. And the fourth effect, this is in point of fact, is that he remained in detention for those 75 days without charge. None of the evidence as to the effect of those events on my client is challenged. It is to be found in his witness statement from paragraphs 10 and from paragraphs 100 ongoing to the end of that paragraph. As regards causation, Dr. Clegg gave evidence that if the conditions complained of by my client were as he described, and the court will find that they are as he described because he was never challenged, that is Mr. Ramsamooj, about any of them, then Dr. Clegg says those would have caused a deterioration in a pre-existing number of injuries which Mr. Ramsamooj had and which the State of Suriname was aware that he had. And if you disbelieve Mr. Ramsamooj that he said anything about it when he first entered Kaiserstraat on the 7th or 8th of October, then you ought to believe the diplomatic note dated the 26th of October, in which the state of Trinidad is saying this man has several pre-existing conditions that require attention. The evidence of his stroke in June of 2020 and of the implications of that are to be found in his witness statement beginning at 20:22:25 and going right up to paragraph 76. His wife, who with a degree of obviousness, I say, is in close proximity to him and therefore witnesses to his condition, it deposes to the effects at 23 through to 34. And I rely as well on the evidence at 116 to 120 of the witness statement of Mr. Ramsamooj and 39 to 52 of Ms. Paji.
On the issue of causation, I'm a little intrigued by that. You are suggesting that the conditions under which Mr. Ramsamooj was held in detention contributed to the deterioration in his health. To what extent is that deterioration due to the detention as opposed to the Perkin? Because I assume you are not arguing that it was not legitimate for the authorities in Suriname to detain someone on suspicion of criminal activity. So if the person is detained on that suspicion and suffers a decrease in health, that would not necessarily be actionable. I gather you're saying the difficulty here is that he was kept incommunicado under the B. Perkin, and that was an underlining factor. So I'm just trying to understand how you attribute the deterioration to the B. Perkin, which in your view was unlawful, as opposed to a detention, which in your view might not be unlawful.
Yes. Your Honor, the key for the claimant's case is the denial of access to counsel and the denial of the opportunity to agitate the full plethora of his remedies. Your Honor is quite, I beg your pardon.
I follow you.
Yeah.
I was just thinking, however, that you also mentioned the prison conditions.
Yes.
Or the conditions of detention, which were not satisfactory, according to you and to Mr.
Yes. And that
Ramsamooj.
that is part of.
Yes, and he had, of course, pre-existing medical challenges.
That is part of our.
So that in any event, be Perkin or otherwise, if he was confined, then it would not be unreasonable to suspect that that may have contributed to a deterioration in his health.
Your Honor, can I say this, frankly? Yes. Your Honor is perfectly correct. What I am asking the court to do is to assess the possibility that had he had counsel on one of those 3 occasions when his detention came up for challenge or assessment, the fact that his passport had been seized since the 6th of October would have led, and I will show you in the evidence of Dr. Clegg that this is precisely the point of fact, would have led to a release from the conditions that caused the medical problems. So I take your point that there is nothing to prevent Suriname from saying, your boy, your client, is a criminal suspect, and he must go through, like everyone else, the criminal process. That is not my case. My case is 2 things. First, I challenge the validity of the B. Perkin and the effects that it had on my client. And secondly, there were 3 occasions when, had I had a lawyer, the likelihood is I would be out, and all that Dr. Clegg is saying is that if you remove the individual from the prison and put him in a hotel room, his chances of not suffering a stroke and not having serious deterioration of his health are going to improve. And in fact, that is what Dr. Clegg says. Dr. Clegg wrote a letter at the time, not saying that you must release Ramsamooj and not subject him to the criminal process, merely saying that taking him from prison, it is an annexure to Dr. Clegg's witness statement, and putting him in a hotel room is going to prevent a deterioration. And what is magical, if I might be permitted that term, about Dr. Clegg's evidence is it is predictive. He writes the letter, and the stroke happens. But I don't hide from the fact that I don't have a clear submission or unequivocal submission that, and I don't think that I can have a clear and unequivocal submission that because he was imprisoned, he has suffered this deterioration in health, because I can't overcome the fact that he is a criminal defendant. My question, or this case, is about how you treat criminal defendants. I don't challenge that he's a criminal defendant. My position on that is that he's 100% innocent, and we could establish that, and the time will come for that.
Yeah, no, Mr. Phelps, just one question, going back to the judicial hearings on the 13th of November and the 9th of December. And the point you've made more than once is that he was without a lawyer. At that time, the B. Perkin orders had come to an end. What does he say about the fact that there was no lawyer present on those dates?
The evidence is that the prosecution service is responsible for giving notification of those hearings, and that the lawyers are saying that we would get 20 minutes notice or a half an hour's notice to appear at a hearing and not be able to make it. And that evidence is in the witness statement of Mr. Ramsamooj. May I make one further point? None of the evidence of Mr. Ramsamooj was challenged. Yes, not challenged.
Short.
Yes. Yeah. But there's one further point I would wish to make. Of those 3 hearings, Your Honor would want to register that the first of them took place during the pendency of the beperking. So you were not in that event going to have a lawyer in any event. Can I turn now to the question of interpretation? Again, I wish to use freedom of movement to bind up all of the rights. I do wish to all of my submissions to apply to all of the rights. And at the appropriate point, I hope that I will deal with all of the questions that the court has for me on that. The materials available to the court to decide where this Charter of Civil Society stands are contained by description or categorized in Article 31 of the Vienna Convention on the Law of Treaties, which this court has repeatedly deployed as an aid or the rule to interpretation of the revised Treaty of Chaguaramas. There are headlines in that article with which the members of this court would be too familiar for me to read, but I would like to identify what we say are the headlines. A treaty should be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of the object and purpose. So good faith in their context and object and purpose. The context for the purpose of the interpretation of a treaty shall comprise, in addition to the text, including the preamble and annexes, an agreement relating to the treaty which was made by the parties in connection with the conclusion of the treaty. And there we have what we submit are 5 indicators as to where this interpretation should be going. And the 6th is at 31.3c, any relevant rules of international law applicable in the relations between the parties. When you take those indicators together, you will find, as we submit, that the objective of the application of those principles to the revised Treaty of Chaguaramas is to obtain an obvious, logical, and effective interpretation of the treaty. And we say that our submission is logical, it is obvious, and it is effective. And that submission is, as we respectfully submit, simple and plain. It is that certain minimum conditions must exist in order for there to be an effective right to freedom of movement. And one of those minimum conditions is the minimum protection of basic human rights. With regard to the first indicator to be derived from Article 31, the object and purpose of the treaty, I don't need to spend any time on this because it is all over the jurisprudence of this court that it is a fundamental objective or fundamental goal of community law, that there ought to be an unimpeded, full, and effective right to freedom of movement. And that is one of the instances in which that was decided is the case of Myrie at paragraph 62. And
Mr. Phelps,
I
I
beg-
wanted to get directly to certain points now
Yes.
that you are addressing the central claim that the rights which the RTC gives to peoples of the community wouldn't really be effective unless a certain standard of human rights is recognized. So I want to zone in on that core argument. As I understand it, you're arguing that even if the CARICOM Charter is non-binding, that point holds. And so what I wanted to first ask is, in discovering what this standard of human rights is the Charter the only instrument that the court could have regard to, or the only source or text the court could have regard to? And if not, what else could the court have regard to?
our answer is that the court can have regard to customary international law and to the Charter. And our further answer is that there is no reason as a matter of interpretation why the court would look to customary international law if there is a bespoke preambular document that indicates what minimum protections ought to exist in order for the right to free movement to be effective.
Okay. The community has made certain submissions. I'm going to directly cross-reference those so I could elicit your response to them. The community in its submissions has pointed to the source of general principles of community law as a source of law that this court can apply. And the court in previous cases dating back to TCL and CARICOM has pointed that out. If the court were to agree that general principles of community law is an appropriate source for discovering this standard, this minimum standard of human rights, again, I'm going to be more direct. Could the court look to the constitutions of member states in the community? Could the court look to international instruments other than the CARICOM Charter to discover what these rights are?
Absolutely.
Okay.
May I develop my answer?
Thank you.
My case is based on certain facts, and it stops at the point of me proposing that it is legally correct that in order to have an effective right of freedom of movement, I have to have basic human right protection. Where the court, and if I might say so with respect, it really is a matter way beyond the peoples of the community, so to speak. The court is in charge of policing the revised treaty. Where the court gets that minimum standard from is a question for the court. We think, because the law, community law, must develop with certainty and predictability, we think that it is wise, or perhaps I should put it this way, the court might consider it wise to have some objective standard by which to measure whether the right to freedom of movement.
But Mr. Phelps, hold on. Yeah, I think what our sister is asking you is something a little different. So that because of that certainty and collective sort of will point, you want to point to the Charter and say it's in the preamble. We get that. What we're asking is something more. Let's move past that. If we have to find sources, that may be a source. Are there other sources? If we have to look for, where do we find a collective sort of composition of these minimum rights? And the suggestion to you is, can we look at the constitutions of member states? Are there bills of rights that are entrenched? If they are entrenched, qualitatively and quantitatively in an assessment, is that evidence that we should look at to discover a common pool of values? Should we look at international treaties that CARICOM states have signed and ratified, which touch and concern human rights? Would those be, so that this is a Caribbean community, in their constitutions entrenching bills of rights, or the Caribbean community signing and ratifying international covenant treaties and conventions dealing with human rights? Are those legitimate sources for us to look to, together with
Yes, the answer to that question, as far as the claimant's case is concerned, is yes. Well, I'm sorry I misunderstood the question.
No, that's fine. And so, Mr. Phelps, I have a follow-up question. In this process of discovering this standard, would these rights be absolute? And if they're not absolute, how would the limits on them be identified or discovered?
The rights would not be absolute. And if there were to be restrictions on those rights, I presume that they would be identifiable from the investigation described by His Honor Justice Jamada. But there is a further answer that the claimant's case has to that question. And it is this, that the Charter answers those questions by being a document which is not directly enforceable, but which does or is descriptive of the conditions which must exist in order for the right to free movement to be effective.
Mr. Phelps, you might want to speak to Article 2 of the Charter, because you mentioned it and my sister asked about whether the rights were absolute. And when you look at, I believe it is 2E, it does speak about subject to such exceptions.
Yes.
And qualifications as may be authorized by national law.
Yes.
And this is interesting, and this is where Justice Jamada, I believe, is coming from, and which are reasonably justifiable in a free and democratic society.
Yes.
So there are exceptions, but there is an important.
Yes, and Your Honor, can I just say this? Again, I hope I am not missing the point of the question. That is precisely why the claimant says that the rights are not absolute, but the Charter is there, and it does have preambular space. And whatever it says, somebody needs to determine the answer as to what the full content of the right to freedom of movement is. So that if the right to freedom of movement does not engage the Charter at all, or customary international law at all, you have an effective right to freedom of movement if you enter a member state and become subject to arbitrary detention. So
But
yes,
yeah, but
yes, but we are saying that somewhere within the body of the RTC, there is the question that has to be resolved by this court as to whether your treatment by the national law, which we accept is a caveat to the right, is in accord with the right to freedom of movement.
Yes. Again, I'm sorry to be your timekeeper, but I'm just advising you that you have less than 30 minutes to go. And it's unkind, having said that, to delay you further on this point. But I want to ask you a question on it nonetheless. Are you proposing then that the court adopts a community standard for the infusion of human rights in the exercise of treaty rights, as opposed to and distinct from the national standard? Because, of course, you could have a discrepancy between the two. So I assume that in Suriname, for example, the nationals of Suriname are subject to B. Perkin. And the question then arises, well, if that's the case, why should Mr. Ramsamooj not also be subject to B. Perkin?
Yes.
You see what I mean? So
yes.
There could be a difference between the national standard and the regional.
May I try to answer the questions, because I think they're all connected. The way that the claimant's case says it works is that you have to identify what the content of the right to freedom of movement is. You may correctly say that the right of the content to freedom of movement includes, subject to national law, the right not to be subjected to arbitrary detention. And inevitably, in order to determine whether that right to freedom of movement has been violated, you're going to have to inquire into whether the particular national law is just or not, whether it is a justifiable exception or not. And I can go further with respect and submit that that is exactly what this court did in Myrie. In Myrie, the statement at paragraph 97 of the judgment in Myrie is that the body cavity search to which Ms. Myrie was subjected was a breach of her right to freedom of movement. And if that body cavity search was a breach of her right to freedom of movement, that means that this court had done exactly the exercise, the analysis that her lady has pointed out to me is required. It has said part of the content of the right to freedom of movement is you have a basic level of human right protection. We don't define it. You didn't define it in Myrie. And the fact that you have been subjected to a body cavity search could not be defended by national law exceptions. And therefore, there's a breach of the right to freedom of movement.
Yes. Well, I don't want to get into the details of Myrie, but I assume that there could be circumstances where a cavity search is justifiable.
Yes.
Okay.
But the court was making the value judgment in Myrie.
Yes,
is
yes,
my
yes.
point.
Yeah. So no, I just wanted to be clear on this. So you're saying that even though the national law exists and applies to nationals, it may not be appropriate to apply that law to community nationals exercising the right of freedom of movement.
That is correct. And
Would that not be discriminating against the nationals of the member state?
that is a question that we have not studied. But if the law is violating community standards, then presumably it prejudices all persons, but not under the RTC. So that if this court were to pronounce that a particular national law violated community standards, then within the particular state, that state's citizens ought to have some recourse. It just wouldn't be under the RTC.
I see. Okay, because you and I are familiar with situations in our jurisdictions where persons, okay, they are charged, but then they're held on remand for very long periods of time, 5 years. You know.
Yes,
Yes.
and
So a CARICOM national that is subject to that period of detention on remand, you are saying that that would breach, in your view, the community standard.
yes, and the same set of facts can give
Yes.
rise to two different causes of action. If I am a Barbadian in Trinidad and incarcerated for 12 years without a trial, I can come to the Caribbean Court of Justice and say that my right to freedom of movement is being violated. My Trini brother is going to have to agitate that in the Trinidadian context, but that is not going to mean that the right to freedom of movement does not have the content which we argue for. But can I just say this, that all of the concerns that the court has raised with me are reconcilable with an interpretation of the RTC that says your right to freedom of movement must be exercised in order for it to be effective in an environment in which basic human right conditions prevail, subject to the national exceptions. And although my Lord says, His Honor says that we're not going into Myrie, I would submit as a matter of stare decisis that is what the court did in Myrie.
Okay.
Mr. Phelps, just to be clear, I recall at the start of your submissions, you referred to a number of relevant rights. I recall you mentioning access to legal counsel, the right not to be subjected to cruel and inhumane punishment, and the right to freedom from arbitrary arrest and detention. And I just want to confirm if those are the core minimum rights that you are asserting would not have been respected in this particular case, that you say form part of the minimum standard or corpus of basic human rights which must be respected to ensure that the right to freedom of movement is effectively enjoyed. I'm trying to confirm that.
Yes, Your Honor, as with all your questions, it is complicated and it brings out several points. The first point is that on the facts of this case, Her Honor is perfectly correct that I agitate the right to access to counsel, the right not to be subjected to inhumane treatment, and the right not to be arbitrarily detained. But there is a wider question, and which comes up inevitably in assessing this case, and it is whether a community citizen is exercising a full, effective, and breathing right to freedom of movement if he travels to another member state and is, for example, prohibited from joining a PNM rally, a political rally. So the reason that I say that your question is complicated is because there are other scenarios outside of the facts of this case that would be agitated, but we hope, and we think that the community citizens hope that you would recognize that that is something that ought to be protected. So that you don't want a right to freedom of movement if when you go to Barbados you can't, or Jamaica, you can't go to a rally and support Mr. Holness or his opposing party and so on. I
Mr.
hope
Phelps,
that answers.
if I understand you, you are advocating that in this case, the relevant minimum human rights that should inform the content of the right of freedom of movement, in this case,
Yes.
are the three you have identified.
Yes, yes.
But you are not suggesting that that is the extent of the basic human rights that the right to freedom of movement may
That is
encompass.
correct. That is correct. And that is why we commend the Charter, because that saves, it prevents the court from having to wander across the international jurisprudence to try to recreate a code that it can then identify is the objective standard that ought to be protected. I know that I am running out of time. I just wish to make two further points about the submissions of CARICOM and some of the academic literature that is written by Professor Berry. First of all, we would like to respectfully adopt and align ourselves with the submissions made by CARICOM. And we would like to align ourselves as well with the academic statements made by Professor Berry. However, we think that some of the literature that Professor Berry has produced could lead to confusion because of his use of the term non-binding to refer to the Charter. And as their honors would be aware, Mr. Berry supports that contention by pointing to the Intergovernmental Task Force meeting in 1996, to the weak implementing provision in the Charter, and to the general community sense that the Charter is non-binding. Respectfully, that could only mean that the Charter is not an independent document into which a community citizen can go and find a cause of action separate to the RTC. That is all that could mean. All he means by non-binding is that you can't pick up the Charter, identify one of its clauses and say that due to a violation there, I have a cause of action before the court. It has to be connected to the RTC. And you can reconcile everything else that Professor Berry says on that basis by recognizing that he, like CARICOM, accept that the Charter is an interpretive tool when it comes to the rights in the RTC. What Professor Berry and CARICOM perhaps do not do is take it to the final step. They acknowledge it is an interpretive tool, but they do not take it to the next step and say what the effect of it being an interpretive tool is. And we say that the effect of it being an interpretive tool is that, and it is deliberate, I'll come to that in a moment, is that when you look at the right to freedom of movement, your minimum conditions for exercising it in an effective and full way are contained in the Charter. It is the Charter that breathes life into the right of freedom of movement. Why do we say that that is deliberate? All of the pieces of the RTC puzzle fall together when you recognize that all of the considerations that CARICOM and Professor Berry point to give support to this idea that it is non-binding are subordinate to 2 points. Subordinate to the fact that the member states took the Charter, whatever the Intergovernmental Task Force was saying about it, and put it into the preamble. So the member states, after all of the discussion, put it into the preamble. And the second material point, as far as we submit, is that they put it into the preamble of a treaty that has a legislative mechanism that recognizes that conference decisions are enforceable, that recognizes that the conference is going to be making community policy. So that the member states could not have been anything but fully aware that you were going to use the Charter to interpret the rights reserved in the RTC. And that doesn't mean that we disagree with Professor Berry or CARICOM. It means that we fully agree with them. We just say that our case requires a final step to be taken consistent with that. Your Honours, unless there's any aspect of the claimant...
I do just want to quickly confirm something that I started with Mr. Phelps. So you have clarified that the reference, you've been using the reference to freedom of movement broadly to also cover the right to provide services and also the right to work as a CARICOM skilled national. Is the case of the claimant really that by virtue of Mr. Ramsamooj's detention, he would have been unable to travel to other CARICOM countries and provide services, travel to other CARICOM countries and work as a skilled national? I'm trying to understand fully what is being claimed here. Freedom of movement could relate to movement within Suriname. Freedom of movement could, the right to provide services could also relate to provision of services not involving travel. So I'm trying to fully understand the scope of restriction on Mr. Ramsamooj's rights that the claimant is alleging would have ensued from the detention. Thanks.
The first freedom of movement arises naturally, we submit, from his detention. Subsequent to that, he was kept in Suriname without his passports until September 2022. And it is his case that he was not therefore able to work within the region, which is the nature of his work.
Yes. I would just say that you make in the originating application and in your submission certain allegations about the criminal procedure in Suriname, about the composition of the courts in Suriname and so on. I assume that you are not seriously asking us to make any pronouncement on those allegations, are you?
As always, His Honour's assumptions are correct. I cannot make that case out.
Thank you, sir. Okay, well, thank you very much, Mr. Phelps. Rick? We will now take a short break. It's now 10 minutes to 12 and return at 12 o'clock. Thank you much.
All right.
Mr. Limapo, we're prepared to hear you. Thank you.
Thank you, Your Honor. My presentation will be very short. As you know, this is a dispute between Mr. Ramsamooj and the State of Suriname, and it arises out of its endeavors, Suriname's endeavors as a liberal democracy to pursue and enforce the protection of public morals and the maintenance of public order and safety towards all persons present in the territory, including the CARICOM residents.
Just to underline that point, you're saying that the laws, criminal laws, are applicable to all persons in Suriname,
All persons, Your Honor,
nationals, CARICOM nationals, and foreigners.
also foreigners, yes. Because of the serious suspicion at the time and still, the public prosecutor decided to restrict the direct access of Mr. Ramsamooj to chosen legal counsel. As we heard yesterday from testimony from Ms. Ramsamooj, Camilla Page, and Mr. Ramsamooj, Ms. Lalji was approached indirectly through Ms. Camilla Page to represent the affairs of Mr. Ramsamooj on the same date as the beperking order was issued.
Mr. Limapo, can I just take you to one thing that you have identified here? You said it was direct access of Mr. Ramsamooj to his chosen legal counsel. That's what you said here. So what I want to...
I'm not sure I said that.
Well, it's all right.
Oh, okay, it's, no.
So
What
I'm just trying to clarify, did you mean to a particular counsel who the authorities felt could interfere with the due investigation, or was it omnibus in the sense that it was in relation to all, any, and every counsel?
Your Honor, it was in relation to all and every counsel.
Ah, okay, right, yeah.
Yes. Ms. Lalji was approached on the 8th of October through Ms. Camilla Page, and Ms. Lalji, as counsel, wrote a representation letter to the Prosecutor General's office. That letter was dated the 8th of October, and yes, she mentioned therein not only that she was asked to represent the affairs of Mr. Ramsamooj, but she said also, I called at Keiserstraat, Bureau Keiserstraat, and they couldn't tell me where he was at that moment. Something along those lines.
Just to confirm again, at the point where Mr. Ramsamooj was classified as somebody to be questioned as a person, to the point where he was classified as a suspect, was there a detention order issued in respect of Mr. Ramsamooj?
Yes, Your Honor. That intention order, and it's only in the disclosure. It was not translated. It was only in the disclosure documents. But there is a detention order. Let me see if I can. I think this is it. This is the detention order, and there's also so it's number 4,100 up to 4,102. And there's also a backflip, which apparently I just recognized today was not put in the disclosure, a backflip. But we would appreciate if it would be possible to submit that to the court at another date, and maybe have this translated for you. So this is the detainment order.
Yes. Well, I don't know whether Mr. Phelps has any views on this. We don't see any particular harm, but we are subject to counsel.
Your Honor, if the court wants to see it, we couldn't properly oppose that. The only question that I have is, it sounds as if what my learned friend is speaking about is a document that is in the papers but not translated.
And missing a
What
page.
caused the backflip? I am suspecting that that is where my client's signature is alleged to be. That is going to be the new document coming in.
I see.
And that raises questions about the provenance of the document. I only say that because it is something for the court to consider. But if the court wants to see something, I am not going to be in opposition to that.
Thank you, sir. Okay, so yes, we will have a look at it. Can you just summarize for us, though, very briefly? I know it's in Dutch. What this says?
On Thursday, the 8th of October, 2020, at 11, is brought before me, and this is Inspector of Police, Mr. Ramsamooj.
Yes.
Mr. Ramsamooj was brought before him,
That's right.
and oh my God, sorry for that.
Into the signature.
And Mr. Inspector of Police writes down that through the interpreter, Mrs. Ramsunder Singh, he told Mr. Ramsamooj that on account of Article 21 and 30 of the Code of Criminal Procedure, he is not obliged to give answers. So it's the caution, and that he can ask for the support of a legal counsel. After having put into words what the facts and what the facts and circumstances are, which make Mr. Ramsamooj a suspect, I told him that in the interest of the investigation, he is hereby detained. In answer to which Mr. Ramsamooj answered, I deny having committed any felony or criminal activity. The only thing I did is, on account of my work, I have executed instructions or work. And then he goes further and gives a statement.
Is this where the B. Perkin is mentioned?
No, no, sir.
Not here, okay.
No, this is not the beperking. This is the detainment. The
Just the
beperking is a
detainment.
separate,
Okay,
separate
alright.
document, same
Okay.
date.
Okay.
So Ms. Lalji was approached. She wrote a letter to the prosecutor's office same day, and she, after 4 or 5 days, was, I think the 12th of October by heart, she filed an appeal or objections to the beperking order, apparently because I don't have the application. We just know this because of the letter that was referred to, and in which she says that she withdrew it at a certain moment, and she says because the prosecutor told her that Mr. Ramsamooj was not, did not appreciate her support.
Mr. Limapo, does the defense, has the defense submitted, even as a disclosure document, the alleged document that Mr. Ramsamooj would have signed that would have notified him of the issuance of the beperking order? We would have heard from previous testimony that that would have been how he would have been notified of the beperking order. He would have been, a translator would have been present, would have summarized the order that would have been issued, and then he would have signed a document signifying that he would have been advised of that. Has that been produced?
So just to be sure that I understand you clearly,
Yes.
Your Honor, which document? You mean the notification document of the
Right, so
beperking?
we would, yes, we would have been
Yes.
discussing yesterday
Yes.
the requirement to notify
Yes,
the suspect.
It has been, it's in the disclosure documents,
Okay.
but it's not translated.
All right.
It's in Dutch.
When you're able to, could you point the court to where that document, even though it is in Dutch, can be found on the record?
Yes, Your Honor. This is one of them. This is the renewal of the beperking. That was, I mean, when I read it, there should be a receipt signed by Mr. Ramsamooj. That's not what is in here. What is in here is a statement from the police officer saying that an official statement saying that he visited Mr. Ramsamooj together with a translator, an official translator, and gave him the beperking order, and it was translated to him, and then Mr. Ramsamooj signed, but didn't sign on the document.
Right, so to be clear, what you're pointing us to, first, could you direct us to the part of the record of appeal this document appears at? What's the page number, please?
Just 1 second, please. 4502.
So, just to be clear, is this a report?
This is a referral report.
And just to follow up, Mr. Limapo, so this document you're pointing us to is a report provided by the police.
Yes, Your
Right.
Honor.
Similarly, we would have had references yesterday to police reports captured at Annex B
Yes.
to the defense of the state of Suriname. I believe those are the documents in which the alleged confession of Mr. Ramsamooj is contained. So, again, has the state produced any document signed by Mr. Ramsamooj that would first have captured, that would have been signed by him, and that would have captured what he would have, well, the statement he would have given during that initial investigation? I'm asking because Mr. Ramsamooj's evidence is that at the conclusion of that initial interrogation, he would have been presented with a document in Dutch. The translator would have summarized the contents of that document, and on that basis, based on the summary he was given, he would have signed it. I want to just confirm, has that document been produced?
Yes, Your Honor, but that document has been produced in Annex B, I think, of the Statement of Defense? Or
But
which,
the reason I'm asking is Annex B is a report given by the police,
okay.
which
now I
has
understand.
no signature of Mr. Ramsamooj on it.
Oh,
It's a police report that was translated.
Okay, then, yes, but it's not translated, but that's then in the discovery documents in Dutch.
So again, if you can point us to where we can find that document, meaning the document that Mr. Ramsamooj alleges that he signed on, it would have been the 8th of October, even if it is in Dutch.
I have to pull this out, Your Honor. It's, I'm not sure whether the Dutch has been put in because I can't pull it out as fast, as swiftly. So I'm not sure whether the Dutch version, which is the complete version, has been put in the discovery.
Yes, I think we understand. We're happy to get the document afterwards, so as not to detain you too long on this point. But we assume it's one of the documents disclosed by you pursuant to the order of the court. We assume that that is the status of the document, but you just can't find it right now in the bundle.
Yes, Your Honor.
Okay, that's fine. So we'll pick it up later on. You wanted to continue with your submissions?
So Mr. Ramsamooj was notified of the restriction orders on the 8th and the 16th of October. I think I'm repeating myself, but just to start over again. I don't have the receipt. I have a police report saying that it was submitted to him and explained by a translator.
We understand. And
both are
you're making the point once more that this is how a Suriname national in an equivalent situation would have been treated. No difference.
No difference, Your Honor.
Okay.
To be sure, jail time in Suriname is no pleasure. I mean, I'm frank about that, but that's for everyone. It's for local people, it's for CARICOM citizens, and it's for foreigners, other foreigners. It's the same for everyone, but yes, it's no pleasure.
Yes, but counsel on the other side is saying that there should be a minimum standard which should be observed in relation to CARICOM nationals, and that's inherent in their right to move freely and to provide services, etc. Do you understand that point, and how would you react to it? That, okay, it's the same across the board for everybody, but that is too low a standard when we're talking about the exercise of rights under the revised treaty. How do you respond to that point?
Your Honor, the way that I have read Mairi and I think it's Tamilka judgments, the potential breach was always based on discrimination, on the discrimination principle.
Yeah.
Up to now, that is the way I have read it and understood it, was the discrimination principle. In this case, that has not been alleged that there is discrimination, at least, well, there are certain remarks made by Mr. Ramsamooj which he says that he had to pay more for translation than domestic people, and then he thinks that he had to pay more for medical assistance than domestic people. I'm not sure about that. As far as medicals is concerned, normally local people, they are insured, and so it goes through the insurance package, etc. But probably Mr. Ramsamooj was not insured or not insured in Suriname. As far as translation is concerned, as far as I know, translation costs do vary, but they vary for everyone. So it's, it depends on the translator that you're contracting. So what I submit is that the application was not premised on the discrimination principle, but it was forthright on human rights or fundamental rights in connection with the freedom of movement of persons. As far as I know, the court has not yet, at least not yet, pronounced any rule in regard to basic fundamental values, common fundamental values in regard to free movement out of the discrimination principle.
Do you think we should?
I think it's dangerous. I cannot say whether you should, but I think it has some risks, and that has to do with, as far as I understand, in the EU, the court did take those steps. It took them some time, but they take those steps. But from what I understand, the policy behind it was especially that the EU itself was pronouncing, what do you call it, richtlijnen, regulations, was pronouncing regulations, and those regulations were exposed to fundamental values of, for instance, the Bundesverfassungsgericht, etc. And to avoid a clash with the European Court of Human Rights and with the local strong constitutional courts, this is the route that the EU took. I'm not sure whether the situation in the CARICOM is similar, probably not, in the sense that the CARICOM does not have a legislative machinery itself. That's what's on the table. I'm not.
Yes, it's on the table. Very well, if I may say so. But,
That's what,
now, Mr. Phelps is saying that there is a bespoke instrument, an instrument tailored for us in the region in the form of the Charter of Civil Society. And that is a document which went through the process of regional consensus and so on. Why should we not use that as the minimum standard for treatment of CARICOM nationals?
because it's probably not intended for that purpose, but it's probably
So
not.
if it was not intended for that purpose, for what purpose was it intended?
So that's obscure, yes. That's obscure for me, for
Yes.
what it was intended. I've read the submissions of the CARICOM as good friend, and I do support those submissions. Yes, I'm not sure what it was intended for, and I'm not sure whether the CARICOM is ready for that. I would.
What would make it dangerous, to use your word, for CARICOM to adopt that as a standard? What about that charter is so difficult of attainment that we should consider dangerous?
Well, dangerous. It's an option. It's an option. I'm just, from what I researched, it's not a binding document, but
Well, there are
it's-
various
it's a-
ways in which a document can become binding. I mean, it may not be binding at the time of adoption, but state practice could suggest an affirmation of the principles in the document. And state practice, of course, as you know, comes in various forms. So I think my colleagues alluded earlier to the constitutions of our member states. That could be seen as a form of state practice. We have had statements by heads of government as well, reaffirming the binding nature of the charter. So, I'm just trying to figure out if there's anything in particular, any particular provision in the charter that you're aware of that you would consider not appropriate for us at this point.
no, Your Honor, I'm not. But then it would probably be in combination with, just as an interpretive tool.
Yes.
That might be a possibility, but also international principles of community law, if it qualifies, if those are there.
Yes. When this court makes a decision in its original jurisdiction, what effect does that decision have in the laws of Suriname?
It could be executed through. I mean, Suriname did ratify and put into place their implementing legislation. So you could. So from the top of my head, you could apply for an exequatur,
Okay.
and then it could be executed.
Okay. So if we were to decide that the B. Perkin, for example, is perfectly lawful, no difficulty with it, then that decision would be taken as, is it law in Suriname?
If it would be a statement, a
Yes.
declaratory statement,
Yes.
it would be law in the sense that Suriname would be obliged to comply, to
Yes.
comply with the decision and make adjustments to the provisions concerned, if necessary. Yes.
So if we said that the B. Perkin, on the other hand, was not lawful,
Yes. Sorry. Yes. In that
yes,
case.
was not lawful, then I'm just trying to be clear, what would be the effect of that pronouncement within the legal system in Suriname?
If it would be declared lawful,
No,
unlawful.
unlawful.
Yes. The effect would be that Suriname would need to comply with that decision, and that the government and every department of governance would be obliged to comply with that decision.
And what would be the consequences for persons, well, in this case, Mr. Ramsamooj, who was detained and then subjected to the B. Perkin? What, if anything, would be the effects of that decision of ours on his situation in the legal system in Suriname?
I think as soon as the court sessions would be continued, because up to now it's in a standstill. But when they would be continued, his lawyer should invoke the decision and ask for the evidence as far as given within that specific, what was
B.
it?
Perkin.
Oh, yes, the Perkin period. Ask for that decision, ask for that evidence to be nullified with the court. And then the court has to decide, reading the judgment and then adjusting their, or considering their decision.
Okay, thanks.
And Mr. Limpo, as far as legislation is concerned, you spoke about adjustments to the present legislation, that could happen as well, or?
Yes, Your Honor.
And that would be across the board, both nationals and
Yes,
others.
yes, yes, it will be across the board. Across the board.
You were going on to say something else before I intervene?
No, I'm okay. I'm okay.
Yes. So I think you had gone to the point of the Charter of Civil Society, and you were telling us about that, why you thought it was non-binding, and
Yeah.
I sort
Yes.
of asked you some questions. I don't know if you want to pick it up from there.
There was also a point made yesterday, and I think it was part of the testimony of Mr. Ramsamooj with regard to the translations or interpretation. And in summary, he stated that he signed on the 8th of October, he signed a statement after only after it, he signed it in Dutch. He signed it in Dutch, and it was only summarily translated to him. I want to clarify that, and I was not present at that session, but from what I understand from the witness, Mr. Ramsamooj, and he checked with the police, and that's the way it normally goes, is that yes, all statements are signed in Dutch, because that's our official language. It's signed in Dutch, but when the statement is, when the questions are asked, they are asked, if they are asked in Dutch, they are translated. The suspect answers in his native language, in English, and the translator translates it into Dutch. When everything is put on paper, it's being read out in English for the suspect. And then the suspect signs. That's the way it should go, and that's the way it normally goes. I just wanted to make that clear.
So, Mr. Limapo, a summary is not normally
No,
read.
no,
It is
Your
the
Honor.
entire statement.
It's the statement, because it is in Dutch, it's read out entirely by the translator in English.
Thank you.
I think yesterday we had Miss Browning in her testimony. I think she explained, and also Mr. The expert from the other side. I'm sorry, I forgot his name, but the expert from the other side. The expert from the other side said that Suriname has a dominant monastic system. And I'm not sure whether that's true. It's a semi-monastic system in the sense that only the provisions of treaty law that are directly applicable are part of our national law after or in the application of local law. So it is within the process of the application of local law, the directly applicable treaty provision is guidance for the court. And they interpret and they apply then that directly applicable provision. And up to now, as far as the expert knows and as far as she has researched, there has been no decision from the domestic courts by which the beperking order was set aside in a concrete matter.
Mr. Limapo,
Yes.
what do you mean by set aside in a complete manner? Meaning the concept of a beperking was found to be inconsistent with some other law in Suriname? Or do you mean the specific beperking order that was issued in a particular case was set aside? Which one do you mean?
The latter one, the specific order in that matter.
That,
I'm sorry. Maybe I should further explain.
yes.
It's not the order, it's the law that they are testing then. So it's the Article 40 sub 2 of our criminal procedure law that is brought to the test when applied by the court in considering the appeal of the order. So what is then set aside? It's the specific law, Article 40 sub 2, is set aside in that concrete matter.
Yes,
Are
so-
you? Yeah.
yes.
I'm sorry.
You go ahead.
Are you saying then that no court in Suriname has set aside beperking as being unconstitutional? Is that what you're saying? Because I'm trying to.
That's also true, but also not contrary to directly applicable treaty law. in the concrete circumstances. So not an abstract.
Right.
But you are saying, though, that there are instances where a beperking order was appealed and the judge may have lifted the order or set aside that specific order. But Section 40, Paragraph 2 has not been found to be unlawful. Is that what you're saying? That's my takeaway from what you're saying.
Yes, unlawful and set aside. They would not say unlawful, they would
Right.
set it aside and not apply it. So they
Right,
would
okay.
they would not apply it, and then of course the order would be
Okay.
lifted. I think, Your Honor, this is what I wanted to say today. I think everything else is in the pleadings.
Okay. Mr. Limapo, I wanted to follow up on a couple of points. In this case, the State of Suriname is invoking Article 226 of the revised treaty. And of course, the burden of proving that the requirements of Article 226 are satisfied is on the State of Suriname, because you're the party invoking the exception. So I noted that at paragraph 23 of the state submissions, that's where I'm seeing 22 and 23. That's where I'm seeing the exception addressed. And so I wanted you to spend a little bit more time, because as I said, the burden is on the State of Suriname to demonstrate why these requirements of this provision are met. I do think that the state needs to address in a bit more detail what it understands the requirements of Article 226 to be and whether they're met in this case. So you are invoking subparagraph 1A of Article 226.
Yes, Your Honor.
And so you are here indicating that the measures, and I'd like you to clarify what measures you're using Article 226(1)A to defend. Is it the specific beperking orders that were issued in this particular case? Is it the entire detention of Mr. Ramsamooj? What exactly are the measures that you are relying on Article 226(1)A to justify? So that's the first question.
That would be the beperking orders, the
Okay.
restrictions.
Okay. And again, Article 226(1)A would be invoked in the event the court were to find that these beperking orders issued in this case are not compatible with obligations of the State of Suriname, or Suriname would have failed to honor its obligations through these measures. Assuming the court were to find that, Suriname has invoked Article 226(1)A. Now, 226(1)A covers measures to protect public morals or to maintain public order and safety. Are all of these components being relied on by Suriname? Is it particular components?
Your Honor, let me try to explain a little bit of the background
Sure.
of this matter. The SPSB Bank is a government bank owned by the government that seems to have been used for corruption matters. So payments seems to have been made to several people, several local and outside people. Payments have been made without underlying documents, for no reason, etc. Mr. Ramsamooj's case is only a very small part of that SPSB investigation. And it is up to now in, I think, 3 or 4 parts already that corruption scandals are being investigated. So it concerns the former managing director, it concerns officials of the government, it concerns, if it's linked to the central bank where you also had corruption scandals, etc. So it's a big corruption scandal, and the prosecutor was convinced that that not issuing the restrictions would hamper the investigations of this scandal, because they were interlinked and there were several, maybe 10 or 12 suspects, which made it very complex and very sensitive, and it was a very high level in the country. So that is more or less the context wherein this took place. The managing director was already convicted for, from the top of my head, 8 years. The central bank president was already convicted for 4 years. The Minister of Finance is a fugitive. He ran out of the country and stays out of the country. Nobody knows where he is. So that's the background in which this took place. So the prosecutor thought, or was convinced, that it would be needed, that the restrictions were issued to avoid that the investigation would be severely hampered. That's more or less what it's about.
So essentially you're arguing that these were measures to maintain public order and safety?
Yes, Your Honor.
Okay. I wanted you to respond to a submission that the claimants have made. So at paragraph 8.24 of their submissions, they seem, well, they have argued that this defense should fail because there's no evidence that the detention was necessary to maintain public order and safety. And I wanted to ask the State of Suriname if its interpretation of Article 226(1)(a is that that requirement of necessity is part of that provision. So if we look at Article 226(1)(a, yes. I'm asking you to comment on whether there is a requirement or whether the state, whether it is the state's submission that it has to prove that the measures it took are necessary to maintain public order and safety. What is the state's position on that?
It is, I mean, it is, the onus of proof is on the side of Suriname. That's by law, that has been decided by your honorable jurisprudence. It's not easy, I think, to fully prove that it's that safety and order, because it's an abstract term, safety and order, and but the facts of this matter were of such a nature that if the restrictions were not issued, the investigation would be hampered, and maybe other suspects would also benefit from that, etc., because there were a lot of other suspects which were interlinked.
Okay. Just to clarify, the reason I'm asking is there are some provisions in Article 226 that don't use the word, that use the word necessary, and some don't. So I wanted to just get Suriname's position on that. But what about the final part of Article 226? So there's language at the end of the provision that's applicable here. It says the state isn't prevented from adopting these measures if such measures are, well, do not constitute arbitrary or unjustifiable discrimination between member states where like conditions prevail, or a disguised restriction on trade within the community. Now, I'm asking this question because Suriname has submitted that an important component that is applicable here is that the measures should not discriminate on the ground of nationality only. Is there anything in Article 226 that suggests that to invoke this exception, the measures have to be, you have to show that the measures do not discriminate on the ground of nationality only? Is that a feature of Article 226 in any way?
You mean for like relying on the exception?
Yes.
For relying on the exception? I don't think so, but it's non-discriminatory. This is a measure which has been issued only on one person at this time, but I think even the claimant has stated that, and the expert of the claimant have stated that it has been applied all over with regard to all kinds of criminal activities and irrespective of nationality.
Thank you.
Thank you very much. I see no further questions for you, Mr. Limapo.
Thank you.
And thank you again for your submission. So we will take the lunch break at this point. I think we're back on schedule and return at 2 p.m. for the amicus presentation. Looking forward to that. Madam Registrar?
All rise.
Court resumes, and we're pleased to hear from CARICOM at this point.
Thank you, Mr. President, Your Honours. Good afternoon. Your Honours, we were asked as amicus curiae to respond to two questions that were posed by the court, and we did so and filed those responses in April of this year. Of course, Your Honours, since we have filed that, we've also seen various things filed by both parties. We've listened very carefully for the last day and a half, and some things have come up from Your Honours and also from counsel and the witnesses and the experts that I think in our role as amicus, it is our duty as the community to assist the court with some reflections that we may not have fully addressed in our answers to the court, but I think the benefit of having been here and been present is that we are able now to address the court in a little more detail. So with your leave, we are here, Your Honours, and I think it's important to point this out, because there is an argument that the treaty intended a right or benefit conferred by or under the treaty on the contracting party to which the applicant belongs, which should inure to the benefit of the applicant directly. Your Honours, it's probably trite to say, but very true, that the community is a regional integration movement. It's more than just a political or economic union of member states, and that in this union, citizens of the community do have inalienable rights. And so in responding to the first question posed to us by this body, we start out by saying that the Charter is a statement of the intention of the member states of the community to recognize that its citizens are to have certain fundamental human rights in keeping with the ethos of the Treaty of Chaguaramas. When one looks at the resolution that was signed by the member states of CARICOM adopting the Charter on Wednesday, February 19, 1997, it states that the heads of government, being committed to the fundamental principles of human rights and freedoms and conscious that the Charter should enhance the regional integration process, and conscious that, and declares that they are determined to pursue the principles in the Charter in response to the challenges of the 21st century. And then they go on to state that they resolve to adopt this Charter and agree to pay due regard to its principles and to ensure that this Charter receives the widest possible circulation within our respective member states. So that gives us the context in which the Charter was promulgated. Suriname, in fact, as a state, signed the Charter. It entered no reservation to the Charter. And as a side note to something that I listened to the court ask one of the parties yesterday, Suriname never entered any reservations to the revised Treaty of Chaguaramas either. So it accepts what is here as a whole. And that is important because the very preamble, as we pointed out in our submissions, to the RTC states in the final preambular paragraph, quote, recalling further that the Charter of Civil Society adopted by the Conference of Heads of Government on 19 February 1997 reaffirms the human rights of their peoples. This court, Your Honors, in the Shanique Myrie case, demonstrated that the preambular provisions of the revised Treaty of Chaguaramas may be used to understand the purpose of the CARICOM CSME, including the commitment to fundamental human rights, to interpret the scope and the meaning of Article 45. Words in the RTC preamble have meaning. They are not just ideas. They are not just empty phrases. They disclose the intent of the community, and as this court has already observed, they are justiciable as an interpretive tool. And in the 2009 original jurisdiction case of Trinidad Cement and TCL Guyana Inc. and Guyana, to which we refer in paragraph 30 of our submissions, the court referred to the RTC as a living instrument and stated that its preamble is an important part of its context. The court said, through the preamble, one is made aware of states parties' goals and statements of principle by which they propose to be guided, and therefore the preamble must be interpreted so as to give the spirit and purpose of the treaty. Also, in the Shanique Myrie case, the court stated at paragraph 10 that it should be noted that the court is an international court authorized to apply such rules of international law as may be applicable, of which human rights law is an inextricable part. It stands to reason, therefore, that in the resolution of a claim properly brought in its original jurisdiction, the court can and must take into account principles of international human rights law when seeking to shape and develop the relevant community law. And in fact, several of the Charter's provisions complement and reinforce the binding obligations contained in the RTC. For instance, Article 2 of the Charter enshrines respect for fundamental rights and freedoms, including freedom of movement within the Caribbean community, which is an entitlement that finds binding legal expression in Part 2 of the RTC. Similarly, Article 5 on equality before the law aligns with the RTC's prohibition against discrimination only on the grounds of nationality under Article 7. The Charter further elaborates on democratic governance, transparency, and accountability in Article 17, which supports the obligation of member states under the RTC to operate within frameworks that facilitate economic integration and functional cooperation. Having listened to the court, Your Honors, I do wish to now put something before the court for your kind consideration. And it is this. The CCJ has affirmed the applicability of legitimate expectation in the context of CARICOM law and the RTC on the basis that adherence to the rule of law requires that the community not disappoint legitimate expectations that it has created unless an overriding public interest requires otherwise. The court has recognized both procedural legitimate expectation, that is the expectation of a fair hearing or of a specific procedure being followed, and in certain circumstances, also substantive legitimate expectation, that is the expectation of specific outcomes or benefits. Now, to establish a claim on legitimate expectation, typically the claimant needs to show that there were precise, unconditional, and consistent assurances from an authorized and reliable source which gave rise to the expectation, and that the assurances comply with applicable rules. In Trinidad Cement Limited and the community, The CCJ affirmed the doctrine's applicability in community law at paragraph 39, noting that the community must be accountable and must operate within the rule of law. It must not trample on rights accorded to private entities by the RTC, and unless an overriding public interest consideration so requires, or there is the possibility of the adoption of a change in policy by the community, which was reasonably foreseeable, the community should not disappoint legitimate expectations that it has created. In the Attorney General and Joseph and Boyce, the court applied the principle in a human rights context, finding that the state's conduct created a legitimate expectation that the applicants would be afforded a reasonable time for the completion of their human rights proceedings before the Inter-American Commission on Human Rights. The court may therefore accept that the adoption of the Charter of Civil Society by the Conference of Heads created a legitimate expectation for CARICOM nationals that they may rely upon respect for fundamental rights and freedoms, including due process rights, equality before the law, and that the inclusion in the preamble of the revised Treaty of Chaguaramas of a mention of the Charter which was adopted as reaffirming the human rights of their peoples gives rise to such a legitimate expectation. That reinforces the idea that the Charter is not just words. The question that the court asked earlier, what does the Charter mean? What is its effect? If it is to have any effect, Your Honors, I argue that it must be honored for the reason that it is a compact between the very highest authorities of the community and its peoples, and that they saw fit to even include the reference to this in the preamble to the RTC. Cementing in the RTC's preamble that the Charter reaffirms the human rights of the peoples of the community. Article 2 of the Charter affirms that states shall respect the fundamental rights and freedoms of the individual without distinction as to political opinion, and mandates in Article 3 that states ensure respect for and protection of the human dignity of every person. So while we submit, as we do, that the provisions of the Charter are not legally binding in the strict sense, in the way that a treaty is, we say that these provisions reflect the shared normative commitments of CARICOM member states and are relevant under Article 31(3)(c) of the Vienna Convention on the Law of Treaties, which does allow for the consideration of any relevant rules of international law applicable in the relation between the parties, so that the Charter would form a source.
Ms. Showman, thank
Yes,
you.
Judge. Yes, Your Honor.
I wanted to take forward that point that you made
Yes.
about the Charter representing the shared normative commitments of member states,
Yes.
and its relevance to interpreting the rights and obligations under the treaty.
Yes.
I'm not sure if you're going to get to it, but I
Okay.
was particularly interested in the submission of the community that the Charter could be also relevant as representing general principles of community law.
Yes.
And I was particularly interested by the observation made that in discovering what general principles of community law are,
Yes.
There could be reference to the charter, but there could also be reference to other sources, the constitutions of member states,
Yes,
international instruments to which member states are parties.
that is so.
And I'm wondering if you care to elaborate on that in terms of how you would see these other sources being referenced in the discovery, I'm using the term discovery,
Yes.
of general principles of community law. And then I do have a follow-up question after that. Thank you.
Certainly. So, Your Honor, one of the ways in which, for instance, reference to the constitutions would be the common principles that can be found in the constitutions of the member states. And I think, as one of my learned friends observed earlier, that finds expression, for instance, in the unwritten but customary law that underpins our constitutions. The notion, for instance, that we have fundamental rights and freedoms, which is evidenced, I would argue, Your Honor, by the fact that the member states were able to develop this charter with principles that they all agreed were applicable to CARICOM, to Caribbean community member states and entities. The fact that these states could get together in 1997 and put together a complete document which is clearly an expression of the idea, as it says, that these are fundamental principles of human rights and freedoms, conscious that being able to elaborate these would lead to a greater integration process because we had these things in common, or because we ought to have these things in common.
Thank you, Ms. Schumann. Just a follow-up question.
Certainly.
When the claimant was making submissions, I asked Mr. Phelps if the minimum standards of human rights, if these standards were absolute. And he responded, no, they would be subject to limits.
Yes.
The charter itself articulates these rights
Yes.
as being subject to limits.
Yes.
So I wanted to quickly explore the interface between the right in this case, or treaty rights in this case, the right to free movement, possibly being understood as encompassing the right to have certain fundamental rights respected on the one hand,
Yes.
and then on the other hand, the existence of a general exceptions clause.
Right.
In Article 226.
226, yes.
So what I'm trying to work through is if in determining the content of these standards, there's an understanding that these standards have limits. So for instance, they could be subject to restrictions that are reasonably justifiable in a democratic society on the one hand, right?
Yes.
So just in determining whether the right has been respected, you have
Right.
to take into account these limits. How do you think that would interact with a general exceptions clause that would allow the state to invoke certain exceptions that would allow them to also take measures that place limits on treaty rights?
I come from the school, Your Honor, that says that there's no such thing as an unfettered discretion. All rights have limits to one reason or another, for one reason or another. Constitutions, when they say citizens have rights, do not make those rights open-ended. The rights will be given, but with certain exceptions being put in. So, for instance, Article 226 of the treaty says that nothing in the charter is construed as preventing the adoption or enforcement of member states of measures, and the one that is invoked here is to protect public morals or to maintain public order or safety. But even when the exception is given, the limit is given at the bottom, which says only if such measures do not constitute arbitrary or unjustifiable discrimination between member states where like conditions prevail. So the burden, as Your Honor pointed out to Mr. Limapo, the burden is on the state of Suriname here to say, yes, but all of these human rights things and all of that, but however, we have the right to do things to protect public morals or to maintain public order or public safety. You may have that right, Your Honor. However, you don't have the right where denying someone due process is either arbitrary or unjustifiable discrimination. In other words, you have to show why a denial of due process, or in this case, a denial of your right to be able to, once you have entered, to also leave, or be free of harassment, or be free of limitations that prevent you from enjoying the benefit you are supposed to have under the treaty. They cannot be arbitrary. They cannot be unjustifiable. Unless you can show that there is some state of affairs in your state that doesn't apply because in somewhere else in the community, you're still able to enjoy those rights. And you can show that there is a difference as to why in your member state this was required to put in place measures
Mr. can I
that
ask you?
yes, sir.
Can I ask you to,
Yes, Your
to
Honor.
help me understand that with a concrete example?
Yes.
So we're speaking very conceptually for now, but can you reduce how you see the exception at 226 and the special limitation that only if such measures do not constitute arbitrary or unjustifiable discrimination as between member states? So
Yes.
how this comparison between no right is absolute, rights can be limited, and this 226 exception, what's a practical example of that comes to mind for you?
Let us say, for instance, I'm going to go to a crime fact situation because I think that might be the easiest for me to explain. Let us say, for instance, in the current dispensation where there is free movement between 4 member states of the community, a Belizean artist was going to Barbados to go and perform. But the state passes a law that says, we're not going to allow anyone to come in who is going to be singing about blowing up places, blowing up people, bad word, the police, kill all cops. You can't come in. That would be justifiable, or the state might well argue that that is justifiable to protect not only public morals, but to maintain public order and safety. Normally, you would have the right to be able to have some freedom of expression while you are enjoying your freedom of movement, but not when it is going to impact or impinge on public morality or public order and public safety. I think the challenge that Suriname has in the present case would have been to demonstrate to your honors why procedures that were used under the laws of Suriname were necessary in the interest of public morality or to maintain public order and safety. And they must show you that those measures are neither arbitrary and that they are justifiable because you are claiming this exception under 1A. It's a not inconsiderable hurdle to cross. I would argue that it's a bit high and that it should be interpreted in such a way that it does not take away from those rights that this court has already said Caribbean citizens enjoy under cases like Joseph and Boyce and the Attorney General or the Shanique Myrie case. I'm not sure if that answers Your Honor.
Well,
But-
it's helping me understand how you see it. Yeah,
Thank
so
you,
it
sir.
does. It is helpful. Thank you.
Thank you.
Yes.
Mr. President?
Thank you, ma'am. I wanted to ask about the thing you started with at first, the binding nature
Yes.
of the charter in the context of our regional law. First of all, I am very sympathetic to the notion that the charter would serve as a useful common denominator for interactions with and between member states. And indeed, as we know, a treaty which has not been ratified can still give rise to legal obligations. Of course, this is not a treaty per se, but declarations as well
Yes.
can give
Your Honor.
rise. A classical example would be the United Nations Declaration on Human Rights,
Yes,
which
Your Honor.
everybody would agree is widely binding. But I want you to help me with two issues. One is, in 1997, when the charter was adopted, I think the general view was that it was not adopted as a binding instrument. So how would you answer that question, first of all?
I would say that I have to agree, because this is true, that there is no explicit reference to any legally binding nature of the charter in the charter itself or even later on in the RTC. However, why put it in the preamble, squarely in the preamble of the RTC, stating that it reaffirms the human rights of the peoples of the Caribbean, unless it was meant to have some meaning, even if that meaning was as an interpretive tool or as a tool to assist decision makers in coming up with policies and principles that underpin the charter, that underpin the treaty. Otherwise, Your Honors, it is just a bunch of pretty words that don't have an impact on the real lives of real people in the community. And I think this court has already crossed the Rubicon of that idea in the Shanique Myrie case, and also in cases like Joseph and Boyce.
And to that, I think we could also make note of the fact that the charter was adopted 28 years ago.
Yes.
So we're talking about a pretty long time, and the practice of states could have developed in a way that support the binding nature of the charter now. So I hear you. The other question is probably a little bit more difficult. I'm trying to understand the transboundary application of the charter. Because when you read the revised State of Suriname, it does say that, for example, university graduates are able to go to other CARICOM states and enjoy the right to seek employment. But when you read the charter, it doesn't seem to be worded in that way. The charter seems to be worded in a way which encourages, urges, mandates even, the member states to take action within their member states to ensure certain rights of their people within those member states. So I'm just wondering how we move from that national obligation to saying that it applies across the region. It applies to CARICOM nationals from other countries now resident in a different CARICOM country. Those nationals enjoy the same rights.
I would argue, Mr. President, that you have to look at Article 45, in which the member states commit themselves to the goal of free movement of their nationals within the community, and that has to be looked as the overarching principle, and that the regime which follows, that is the movement of skilled community nationals, has to be seen as being in furtherance of that goal. And so, as Your Honor pointed out earlier, the movement along the development of a community as an integration movement is a continuum. It's not static. It keeps on developing. And this is why I am saying that I'm taking the bold step of suggesting that it is open to Your Honors to say, when you look at it, the Charter was a promise to Caribbean peoples. It was a legitimate expectation which community nationals are now entitled to say, hello, but you promised this to us, including, for instance, in this case, the claimant, who is using the skills certificate regime as set out in the treaty, exhibited his skills certificate to show that he went to a member state in the community to exercise this right that he has of freedom of movement, and then alleges that certain things happened to him which amount to arbitrary detention, denial of due process, and is asking this court to find that this constitutes a breach of core obligations under the revised Treaty of Chaguaramas.
There are some provisions, though, which may not lend themselves easily to being transposed in the way that you describe. So if you look, for example, in the Charter, Article 25, that article speaks to reporting obligations. And
Article 25, Mr. President?
yes.
In the Charter, the functions of the Secretariat.
Is it 25? Let's see. Reporting. Yes, 25, reports. So that the states undertake to submit periodically to the Secretary General of the Caribbean Community.
The reports.
Yeah, reports on implementation of the Charter.
Yes. I'm sorry, Mr. President, I got a little confused. You're talking about Article 25 in the Charter?
Yes, I am.
I beg your pardon.
Right. So the question is, would you see that also as being binding? Or are you saying it's only some of the provisions of the Charter that would be binding?
What I think I am saying, Your Honor, is that the responsibility of member states to do certain things under the Charter are things they themselves promised that they would do. Now, might there be a case someday that some community nationals could come and say, you promised me these things and you promised that you were going to make periodic reports and you've done neither. That is a possibility. But for the meantime, there is nothing in the Charter that suggests that there is any sanction or penalty if these reports are not produced. But the court may have to face that someday, and when it does, what it may be coming down to is having to say, You signed a document saying you were going to do it. So it's not just that you put something out there as a press release. You signed a document saying you were going to do it. You haven't done it, and you ought to do it. And you may be able to only make a declaration, but that doesn't mean, Your Honor, that it has no effect.
Yes, and I could see very well a very strong argument being made where there is an overlap
Yes.
between customary rules, peremptory rules of international law, and the content of the charter. Because in those cases, it is a force not just of the charter, but of international law supporting the charter.
Just so.
Yes, I think there are some provisions, such as the reporting, for example, that might be difficult to fit into that category. But certainly there are many other provisions that would.
Yes.
And I would see the force of your argument there. Thank you much.
Ms. Schumann?
Yes,
I find
Brenda.
it interesting that when I look at the resolution of the charter, the heads committed to the fundamental principles of human rights and freedoms, and conscious that this charter should enhance the integration process. And I notice in answer to the Honorable President that you use
Yes.
that word, what integration. How do you see this commitment of the heads working out, as you put it, for the citizens of the community?
It has to have some meaning, or it would not have jumped out at Your Honor in the same way that it jumped out at me. It is said over and over again that the community is an integration movement. We are meant to be pulling closer to each other in terms of efforts like harmonizing laws, in terms of efforts like recognizing that there is a core body of fundamental rights and freedoms that the peoples of the Caribbean are entitled to, and that the entire purpose, I would argue, Your Honor, of placing the reference to the Charter in the preamble of the treaty is that it was meant to highlight and reinforce the commitment that was made in the resolution that goes just before the signatures appeared. And as I've said, Suriname signed it. There were other member states that signed it. And so I would, again, circle back to the idea that it was a promise that was made to Caribbean peoples, and that it is open to this honorable court to find that that is something that then the court has the responsibility to look at, to see to what extent this is a part of interpreting or of acting as a tool to be able to put flesh on the organization's skeleton, so to speak.
Yes, we're going to have to move on because your time is...
I actually didn't really have
Yes.
anything much more to add unless Your Honors had questions. It was, we have our submissions and we've answered. I just wanted to reinforce the point that we make at the end, which is that national law enforcement authorities are competent, of course, to apply national criminal law in the context of the exercise of community rights. But national criminal law may be open to scrutiny where it restricts fundamental rights and freedoms, unless the state is able to show this court that it brings itself within the exceptions laid down in 225 and 226. It is a burden that is theirs, and I would provide the view, Your Honors, that I think it's a high threshold. It was never meant to be something that is just a matter of saying, I have an exception because of public morals or public order and public safety. You have to show why that is so. You have to elaborate.
Chair, with your leave, can I ask two questions? If I, can I? May I ask two questions? Yeah. Sure. I want to start just, my first question is on what you just said. I'll articulate it in a moment. And the second question is, in the Charter, which of the fundamental rights do you think should be used to give flesh to the freedom of movement right that we're talking about? But the first question I want to ask is this. Under 226, if you have a criminal justice system which is designed for public order and safety, can a state say, well, our system is a system that is designed for public order and safety? That's what the criminal justice system is about. And so therefore, without more, we are within 226. Or does 226 contemplate not simply reliance on what exists, but a pointing to and justification of, whether it is on the basis of non-arbitrariness, rationality, or justifiable bases of something in particular?
Yes.
So maybe if you want to just quickly just respond to that.
I would just say to Your Honor that Article 2, which sets out the respect for fundamental rights and freedoms, and which includes the right to life, liberty, and security of the person, is important. The issue of freedom of movement within the Caribbean community, which is 1E, subject to 2E, yes, subject to exceptions and qualifications, and this is the rider, as may be authorized by national law, and which are reasonably justifiable in a free and democratic society. So the state has to come and say, we didn't give this fellow due process because the entire issue of due process or not having due process, of course, is a fact for Your Honors to find. But if the claimant is able to make an arguable case that he was not provided with due process, hence the entire discussion as to whether there was a valid detention order, as to the validity of the beperking process where you are not allowed to see your lawyer, but you are supposed to make an objection to the beperking within the 3 days of the time that you can't see your lawyer. That has to be justifiable under a free and democratic society and fall within the human rights, fundamental rights and freedoms that this charter says, that the
So, all right,
RTC says you're supposed to have.
All right, so I just want to pinpoint one thing so that I get that from the charter you're looking at 2A and E, but if we look at 4,
Yes,
Article 4,
yes.
because part of the thing is we're talking about access to counsel. But what I just want to ask you, your opinion on,
Yes.
is that the most fundamental right, or is it the Article 4.2 right, which is the liberty due process? In other words, which
Absolutely.
is more fundamental? Is it the access to counsel, or it is the due process of which access to counsel is but one aspect? How would you respond to that?
I would respond that that is correct. And I would say, Your Honor, that the due process is important, as 4 points out, not because it's a principle freestanding on its own, but because it deprives you of personal liberty.
And freedom of
And-
movement
correct.
is inherently part of liberty.
Correct. That is so. And when you look at 5 also makes it very clear that you are entitled to the equal protection of the law and to a fair and impartial hearing, to have legal counsel, all of these things, because they are part and parcel of your right to due process. And due process is important because it impinges on your liberty. And that is what I think counsel was trying to say when he was saying, when I talk about freedom of movement, I'm talking about the whole gamut of liberty and freedom that the CARICOM citizen is said to have and enjoy under this charter, but also because it has been referenced in the RTC preamble, and because you are able to find sources for that idea in the international law, and that you have done so in past cases.
Would you say the international law would go so far back as Magna Carta and the right to be heard as an inherent right of a person who is convicted? Is all of those potential sources?
Why not, Your Honor? Because the Universal Declaration on Human Rights has its genesis in things like the Magna Carta.
Right, yeah. Okay,
It is
good.
part and parcel of the
So
customary
the
international law.
sources are, they are many.
Wide-ranging and far-reaching.
Good, thanks, yeah.
It's a very nice note on which to summarize.
Thank you, Your Honor.
Thank you so much. Thank you
Thank
very
you,
much,
and it
amicus.
has been our genuine pleasure. We always enjoy being able to come and have these matters also us be a part of it and be heard. So we are grateful to you for the opportunity to be amicus in this case.
We appreciate your coming. Thank you very much indeed. Thank you. Okay, so I think we have at this point the opportunity for counsel for the defendant to make a short reply on the submissions of the amicus. Mr. Limapool?
I have nothing to say, Your Honor.
You have nothing to say on this issue. Yes, thank you, sir. Thank you very much. Mr. Phelps? I should say, if you just give me 1 second, Mr. Limapool, a thought occurred to me. Suriname signed the charter. Suriname signed the CARICOM charter, I understand. Would you agree that there are certain legal implications which flow from signing the charter?
Well, Your Honor, that's the question. I think there is like an undertaking clause in the charter. So not binding in the sense as directly binding, but yes, as an there is a commitment.
Yes. Yes. I believe in general international law, there is an obligation upon a state that signs an international agreement to ensure that they do nothing that would frustrate the object and purpose of that agreement. That's something perhaps to be considered. I thought this occurred to me, yes. Thank you, sir. Mr. Phelps?
Your Honours, thank you very much. Could I use my time, please, to deal with some of the questions that have been asked by the court of my learned friend for the community? The first few questions were in connection with the fact that the 1997 Charter was recognized at the time that it came into existence as not being binding. And the second question concerns how we transform what appears to be a national obligation into a transnational obligation. The claimant's submission as to that is that the placing of the Charter in the preamble of a treaty is a legal act. It is a legal act because the member states recognize that they are thereby placing the preamble and therefore the Charter within the body of Article 31 of the Vienna Convention on the Law of Treaties. The preamble is specifically mentioned as part of the context that the member states then recognize that their honors would take into account in interpreting the rights in the Charter. And therefore, as far as the claimant's submission runs, it is a subordinate point of fact that in 1997, at an intergovernmental meeting, it might have been discussed that it is non-binding. The minutes of the intergovernmental meeting are in the record, and they exhibit two important matters of fact for the court's consideration.
I just want to be sure we don't run too far ahead of the place of the preamble
I beg your pardon.
in the interpretation of treaties. As you say, Article 31 of the Vienna Convention is relevant, and it speaks about treaties being interpreted in accordance with good faith, ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose. So the context is one of the things to be considered. And then the context of the treaty, that is subparagraph 2, shall comprise, in addition to the text, including its preamble and annexes, and then it goes on to other things which comprise the context. So there is a ledge on which to rest the preamble as an interpretative tool, but it's perhaps not quite as broad as you were, I think, describing.
I don't want to overstate it. All we are saying is that when the member states placed the Charter in the preamble, it must have been in their mind that it thereby became a material for their honors to take into account in the interpretation of the RTC.
Fair enough. It became part of the context.
Yes.
And the context is one of several things.
Yes, no, I
which are
accept
taken
that.
into account. Okay.
And the claimant says that all of those several things are applied, as it were, at the same time, simultaneously to the meaning. I did not mean to overstate it, but I am saying that if the member states do that, it is certainly a matter of subordinate fact that previously they had treated it or discussed it as being non-binding. With regard to the Intergovernmental Task Force meeting, what you will see is two further matters arise from a careful reading of those minutes. One is that it is true that it is decided that it would be a non-binding document. That is in 1996. But the representative for Guyana makes an important point, as we respectfully submit, and it is this. Why are we having an implementation provision if this is a non-binding document?
I mean the representation for CARICOM, not for Guyana.
I beg your pardon, Your Honor.
Did you say the representative of Guyana? I thought I heard you said.
At the intergovernmental meeting.
Oh, I see.
I beg your pardon. The
Okay.
representative from Guyana is recorded as having made a contribution to that effect. And one of the points that we make in our submissions is that the fact that there is an implementation provision indicates that some level of obligation was to be undertaken. But at the very end of those minutes, in any event, there is a clear unanimity that the document should be effective. And this is where we submit that there is a play on words, and we have to peer through the words and look at the substance. It is true that some persons say that it is non-binding. The fact of the matter is that it has to have some legal effect if it is contained in the preamble of the treaty that you are asked to interpret. With regard to the
Mr.
question...
Phelps, before you move on, are you going to address the legitimate expectation point that CARICOM raised? Do you intend to say anything about that?
I don't wish to say anything more than the claimant respectfully adopts the submissions of CARICOM as to that. The other question that was asked concerns the limits that would have to be placed upon any right to freedom of movement that is interpreted in light of the Charter, and how it interfaces with Article 226(1)(a) and the other articles of the RTC. The claimant's answer to that question is that what you are asked to interpret is the content of the right of freedom of movement. In the course of doing that, using the Charter as part of the available context, as it were, the answer becomes self-evident. It is either that in the Charter you find that a particular right is already restricted, or because you come to a conclusion as to what the content of the right in the Charter, in the treaty is, you turn to 226 to see if that exception applies. I don't know whether that brings any clarity to that particular question, but we say in sum, it is all self-contained within the body of the RTC. And that is the answer that we offer respectfully to the final questions that were asked concerning the Charter ex facie containing rights that may or may not apply to the rights in the treaty. And the answer to that, as we respectfully submit, is that on a case-by-case basis, different rights would apply to the infringement of the right of freedom of movement. It so happens that in this case, the relevant rights are the due process rights and the rights to access to, not to be deprived of liberty, and so on. In a different case, and I say this only by way of attempting to answer the question as it was put, in a different case, different rights contained in the Charter may or may not be agitated. There are just two final points, if you would permit me. The first is, my learned friend for Suriname has taken the point against us that in Tamika Gilbert, this court held that an infringement of the right to free movement was dependent also on an allegation that the person alleging the infringement had been discriminated against. Our answer to that is that upon a careful reading of the Tamika Gilbert judgment, that was not a statement of general legal principle enunciated by the honors of the Caribbean Court of Justice. It is not the Caribbean Court of Justice's jurisprudence that to agitate a violation of the right to freedom of movement, you must anchor it to an allegation that you have been discriminated against. And the last point I would make is that in Myrie, in fact, Ms. Myrie's discrimination case was dismissed, but she was able to obtain relief for a violation of her right to free entry. Your Honors, unless there is any aspect of this that I can assist you with further.
I see there are no further questions for you, Mr. Phelps. Thank you very much indeed, sir. Thank you.
Thank you, Mr. President. Thank you, Your Honors.
Well, I would like to thank everybody involved over these last 2 days. Counsel, of course, we have benefited tremendously from your written and oral submissions. I want to thank you again for that. Both those who spoke, of course, and those who did not speak. Our amicus, thank you. We appreciate, as usual, your assistance. And I know there's counsel for Trinidad and Tobago, which held a watching brief. And you're very faithful to your watching brief, I should say. Thank you very much. Thank you also to the members of the audience. And again, I note that there are witnesses who gave evidence in this matter. We're grateful to you for your attendance. And we recognize, of course, the presence of Mr. Ramsamooj, the claimant in this case. And his wonderful wife, of course, yes. Yes, thank you very much. I'd like to thank the interpreters as well. I suspect that they're still online, doing a great job. Thank you very much. And thank you to the registrar and staff of the Caribbean Court of Justice. We are, of course, reserving our opinion in this matter, as you'd imagine, and we will let you know as soon as we have reached a decision so that we can notify you of the date of delivery. Thank you very much. Madam Registrar?